we have an impressive diversity of participants. A significant number of social sciences scholars, but also researchers in the field of forensic genetics, practitioners in forensic institutes, and police forces. The large majority of the registered participants are from different European countries, but we also have participants from Brazil, Mexico, Russia, Dubai, South Africa, and Saudi Arabia. We are all welcome. Before we begin this symposium, I would like to express my heartfelt thanks to Professor Isabel Estrada Carvalhais, Deputy of the European Parliament, who very generously accepted to host this symposium. The organization of this event has received important institutional support from the University of Minho. Professor Filipe Vaz, Pro-Rector for Research and Projects, Professor Moisés Martins, Director of the Communication and Society Research Center, my thanks and sincere appreciation for all your kind and enthusiastic support to the activities of the Exchange project. On behalf of the Exchange team, I also would like to deeply thank our invited speakers. Georg Bittöcker from the General Secretariat of the Council of the European Union, Leonard Schmitz, Deputy Head of the Austrian Forensic Services, Severin Stubb, Custodian of the Belgian DNA Database, and Victor Prüm, Social Sciences Expert in Forensic Genetics. I will now give the word to Dr. Nina Amlung from the Exchange team, who will explain organizational details of this event. Thank you.
Thank you very much, Helena, for the introduction, and welcome to everyone. My name is Nina Amelung. I'm a postdoctoral scholar in the Exchange project. I'm a sociologist, and today I have the honor and pleasure to guide you through this symposium. This event was initially planned to be held in the European Parliament in Brussels, and generously hosted by the Deputy of the European Parliament, Isabel Estrada Carvalhais, but due to obvious circumstances, we had to transform it in an online format. However, we still do need today your imagination here and there to be in Brussels in certain ways. That we have now transformed the event into an online format and are not physically together in Brussels may come actually with certain benefits that guests are participating who would not have made it to Brussels actually. But it also gives us some changes in terms of the format and how we organize that debate. And I quickly want to introduce a couple of rules of how we want to do that. So we ask you to maintain and keep your microphone muted to guarantee good sound conditions for this event. Please decide how you want to keep your camera as turned on or turned off. We invite you to keep it turned on. We also would like to inform you that this event is going to be recorded and therefore also available afterwards on our website. However, that might influence your decision about using the camera turned on or turned off. In order to organize a discussion at the end of the event, you are invited to post questions and comments throughout the whole event. When using the Zoom chat. So there is, for those who have not yet used the Zoom technology before, there is a function that opens a chat, and there you can and are invited to write your questions and comments. And once you have inserted them, they will be picked up in the end for the debate. We would like to ask you to introduce your background with one sentence briefly, so because we have a very diverse audience, to get an idea of where the question comes from. If possible, you might have a person you directly want to address the question or comment to, then please identify. And we will try to collect as many questions as possible So of course you would have the right to speak yourself and also tell the question or comment yourself, but then please also clarify that when you are writing it. Otherwise it will be collected by me as the moderator and I will read it for you. So I also briefly would like to use just 1 second to express the gratitude to the whole exchange team, and also to make you aware that there is a group of people behind this event and also now available during this event. So if there are any technicalities, we have with us our colleagues Rafaela Granja, Shaila Khan, Sarah Matos, Filipa Quiroz, Marta Matish, and Lara Carvalho, who will be helping in case it's needed. So I would like to give now the word to our host, and Helena already introduced her, and we are deeply grateful to have the Deputy of the European Parliament, Isabel Carvalhais, with us. She is member of the group of the Progressive Alliance of Socialists and Democrats, but she also has a close relationship with the University of Minho. She is Associate Professor of the University of Minho and member of the Center of Research in Political Science in Portugal. She holds a PhD in Sociology from the University of Norway, and she is a full member of the Committee on Agriculture and Rural Development and of the Committee on Fisheries, and substitute member of the Committee on Regional Development. Thank you for being with us, Isabel, and the word is yours.
Thank you, Nina. Thank you very much. Good morning. I hope you're all hearing well. Yes. It's a pleasure. It's indeed a great pleasure to be hosting this meeting to present the results of the exchange project. Obviously, these are odd and difficult circumstances. It's a pity we cannot be physically present in Brussels. And from what I heard, Brussels is having a good time, a good weather which is not always the case. But I think we should stop complaining and instead see the positive side of these things. We are here, we are healthy as far as I'm able to see, and we should be sharing, yes, the cherish, it's the word, this wonderful moment when a community, and from what I see here, we have 105 persons following this seminar. So it's wonderful that we have this moment when a community, a scientific community represented by these 105 people are gathered to have this discussion, to have this debate around a very, very important issue. From my perspective, and as I see it, and obviously you'll have much more interesting things to say, but the first thing I think is that we all talk about individual rights and the relevance of privacy, the relevance of freedom and liberty. And these are very strange times when we see, for instance, extreme right movements and neo-fascist movements going out in the name of individual rights and things like that. But on the other hand, and saying this, we also rely heavily on the benefits of science to keep us safe, to help us out in terms of how to deal with criminality, and this transnational exchange DNA profile for criminal justice and police use is one of such tools that may be considered to be under this kind of debate and discussion. I'm sure many people will tend to look at this as a very, very interesting project where you have science working on our behalf, but at the same time, many will have these questions on privacy and so forth. But this is wonderful, and it's one of the highest moments of a project when we are able to present the results and put ourselves under scrutiny, under the comments of other colleagues, of other peers. And so I'm really delighted, and obviously I'm here hosting this meeting as an MP from the European Parliament, but most of all, I feel someone that belongs deeply for over 23 years now to the University of Minho. So it's wonderful to see so many faces of people that I know, that I admire deeply, and who are also friends. So I'll stop here because I know I have around 2 or 3 minutes, and I'm sure that I've completely used them at this stage. And I will give the floor again to Nina and welcome you all. I hope you'll have a wonderful, wonderful discussion this morning for the presentation of this project. Thank you.
Thank you very much, Isabel, for this warm welcome. I would like to give the word right away to the supportive persons that we have from the University of Minho, and this is Professor Philippe Vage, is the Rector for Research and Projects at the University of Minho. The word is yours.
Thank you, Nina. Just to very briefly, I know we have 2 or 3 minutes just to welcome you all to this symposium, to this well, not very usual meeting by Zoom, of course. But anyway, just to welcome you all to the symposium. A very special word to Professor Isabel Estrada Carvalhais, our Professor Isabel Estrada Carvalhais, so to say. For my colleagues here from the University of Minho, and of course for all the 105, 106 participants. It's a pleasure, it's an honor that the University of Minho welcomes you all here. Well, beyond the Prorector for research from the university, I'm a physicist, so a little aside from this topic, but anyway, very interesting topic. We like to call ourselves a research university, and thus this kind of project is really something huge, something very important for the University of Minho. It's not every day that we have such a project like this. And for that, I would like to kind of congratulate Professor Leonard Schmitz, who I admire very much from the last university that we met, and we are, I mean, discussing very interesting topics, but anyway, we never discussed this particular topic, so I'm very honored to be in this meeting and to take part of it, and to learn a little about DNA exchange, which is the main topic here. And so, just to finalize, and I know that we have very limited time, I wish everybody a very productive symposium, and just to say again that it's an honor to have you all here. Well, not physically, but anyway, to have you all here in the University of Minho. Thank you so much.
Thank you very much for this warm welcome. As a brief explanation, we have the 3 persons and experts from University of Minho joining in one room. That's why they sometimes look at each other, who is Professor Helena Machado and Professor Philippe Vage, and our next speaker. And I warmly welcome also Professor Moisés Martins, and it's a pleasure to have you with us. Professor Moisés Martins is Director of the Communication and Society Research Center and is full professor at the Department of Communication, and the word is yours.
Thank you, Nina. Good morning, everyone. I'm delighted to be here today for the opening session of the Exchange Symposium Challenges to Criminal Justice in Police and Judicial Cooperation, the DNA data exchange within the Prüm system, organized within the framework of the European Research Council Consolidated Grant in the field of bioscience, justice and citizenship. I would like to express my sincere greetings. First and foremost, Professor Isabel Estrada Carvalhais, member of the European Parliament, Professor Philippe Vage, Pro-Rector for Research at the University of Minho, and Helena Machado, coordinator of the Exchange Project and promoter of this symposium. I do also to extend my greetings to the Exchange Project excellent research team and all the symposium guests, which include social scientists, jurists, and bioscientists. And I finally extend my greetings to all participants. The Exchange Project is a very important project for the Communication Society Research Center, which I am representing here today. 100 years ago, if we had held a meeting of social scientists, lawyers, and bioscientists, it would probably have been in the context of a Congress on Crime. At that time, the subject matter would probably have been how to harmonize the proposals of psychiatry with the penal regime, because the social sciences were viewed as an extension of the clinical interrogation process. A century ago, a criminal was considered to be born a criminal rather than being shaped by social forces. Heredity was understood to be the principal cause of crimes. Through application of natural, physical, and psychological determinism, crime was justified by individual factors. But a symposium, such as this event today, no longer focuses primarily or exclusively on the question of crime, nor does it focus primarily or exclusively on delinquent individuals. Instead, the central question is the potential social, civic, policing, judicial, and political uses of emerging technologies in the field of bioscience, and specifically in the field of forensic genetics. Today, through the development of forensic genetics, we have access to an increasingly diverse range of possibilities to pursue joint research between bioscience, law, and social sciences. Science continues to aim to contribute to controlling crime and the establishment of safer societies. But through the development of forensic genetics, the debate is now much wider. Research that makes it possible to identify the human genome is undoubtedly a serious challenge for political science, criminal science, sociology, and anthropology, and even for philosophy, for example, on the limits of technological practices in the case of experiences involving human beings. I would once again like to express my warmest greetings to all participants and hope that the symposium meets your expectations. Thank you.
Thank you very much for those generous words. We come now to a very substantial part of the symposium, as we will hear about the project research results, and we do so from Professor Elena Machado, who is full professor of sociology and dean of the Institute for Social Science at the University of Minho, but she is a foremost principal investigator of the ERC-funded exchange project. Her research critically engages overall in social studies of science and technology, ethics, and criminological perspectives. And her current work explores the challenges emerging from the uses of genomics in contemporary modes of governance of criminality, with a focus on the transnational genetic surveillance of criminalized populations through police and judiciary cooperation in the European Union. And she has been guiding the exchange team in an amazing and admirable way, and will give us a glimpse on the work that the exchange project has produced. The word is yours.
Thank you, Nina, for the very kind words. I will now start. Se conseguir. Desculpa. Sorry for the bit of delay. We're trying to sharing my slides. The transnational exchange of DNA profiles for forensic and policing use is an important tool to tackle serious and organized crime. European Union law, under Prüm decisions, compels member states to create the conditions for the reciprocal automated exchange of DNA profiles, for stepping up on cross-border cooperation, particularly in combating terrorism and cross-border crime. The exchange project's main goal is to study the social, cultural, ethical, and political implications of transnational DNA exchange in the so-called Prüm system within the European Union. Isto não avança.
Helena, peço desculpa estar a interrompê-la. Se carregar como se fosse para apresentar normalmente o slide, lá em baixo...
É o que eu estou a fazer, certo?
Não, a Helena está a usar o modo normal, mas no seu... Exatamente, onde tem agora aí o rato, ao lado do zoom da página, tem... Faça de conta que quer projetar a apresentação, é só carregar nesse... Exatamente aí. Isso, agora é só usar o normal.
Obrigada. Some of the guiding exchange, some of the questions guiding the exchange project are: what are the challenges to criminal justice and police and judicial cooperation instigated by the Prüm system? What is the role and potential value of DNA data exchange between EU member countries in the governance of cross-border crime? What are the implications for citizenship, social control, and democracy in contemporary Europe? While the benefits of using DNA data in criminal investigations are widely recognized, some commentators from the social sciences point out human rights concerns and data protection issues related to the Prüm system. The exchange project recognized the complexity of the benefits and risks of the Prüm system. More than having an opinion or particular positionings about pros and cons of transnational DNA data exchange, the exchange project assumed the mission to give a voice to the different views on this important matter. At the time in which the idea of Europe and solidarity and sharing within Europe is under particular strain, we believe that rethinking police and judicial cooperation is a particularly demanding and urgent task. And I will begin by giving a voice to the views, concerns, and expectations of the professional groups which make the Prüm system operational on a daily basis. The Prüm national contact points that we have interviewed in 22 different EU countries during the last 4 years. Despite national differences in general, the NCPs in charge of complying with the technical standards for the exchange of DNA data information among the member states on a no-match basis are officially called NCPs Step 1. Typically, these NCPs are forensic experts working in forensic genetic laboratories or dealing with ICT systems. NCP Step 2 are police or judicial authorities, and they are in charge of the requests for additional information through mutual assistance procedures. When interviewing these NCPs, we could notice that there was consensus over thinking that the major potential benefits of the Prüm system is to improve crime fighting at the transnational level, and that the Prüm system might speed up police cooperation among different EU countries. one overall risk of the Prüm system, according to these interviewees, relates to its current state of affairs. At present, there are 26 operational countries, but such countries have different levels of connection. For instance, while the Netherlands or Austria are connected to 24 countries, the UK or Denmark are exchanging DNA data with just 7 countries. In addition, the latest report on the progress of the implementation of Prüm indicates that Greece and Italy are not yet operational in the Prüm system. One challenging aspect was the issue of data protection. It was interesting to notice that some participants pointed out that the Prüm system has created higher standards for data protection. Such opinions were justified by the separation between exchanging DNA data, step 1, and receiving further information of interest for the criminal investigation, step 2. Other interviewees stated that the Prüm system might exacerbate data protection issues due to differences in national legislations. NCP's working laboratories declared as advantages of the international exchange of DNA data the harmonization of genetic DNA analysis procedures among different countries, the upgrading of DNA national databases and procedures for forensic DNA analysis, and the opening up of new opportunities to interact with colleagues based in different countries, which poses new opportunities for scientific and technical cooperation. From the point of view of these NCP's working laboratories, there are differences between EU countries in terms of procedures for reporting matches, and associated with that, they have concerns about the lack of quality in forensic analysis in some countries. Finally, NCP's working in laboratories also identified as possible risks the inexistence of feedback on what was the final output, if any, generated by the communication of DNA matches to another EU country. This was viewed as an obstacle to accessing the effectiveness of the Prüm system. And finally, also the potential occurrence of false positives with problematic impacts in legal actions. The Prüm NCPs working in the field of law enforcement international cooperation primarily emphasized how the Prüm system might improve transnational mechanisms of cooperation within criminal investigations, allowing to upgrading and reinforcing of the principle of availability introduced by the Hague Program. This principle stipulates that information available to law enforcement authorities in one member state shall also be made accessible to equivalent authorities in the other member states. These Prüm NCPs working in law enforcement international cooperation also emphasized the challenges posed by the different modus operandi of police and judicial authorities, what they considered to be the excessive focus on DNA matches to measure the efficiency of the Prüm system, the scarce standardization of procedures for requesting information from other countries in step 2 of Prüm, and also the potential use of false positives, which may lead to false incrimination and potential pressure to confirm near matches as reliable leads. Besides exploring the views of national contact points for the Prüm system, the exchange team also worked on other topics related to social and ethical challenges of using DNA technologies for supporting the criminal justice activities. Some topics which deserved our attention relate to controversial technologies, like, for example, forensic DNA phenotyping, which allows to infer externally visible characteristics such as eyes, hair, and skin color, and continental-based biogeographical ancestry. We also explore other DNA technologies which are considered to pose severe challenges to genetic privacy, like familial searching, or more recently, access by law authorities to DNA profiles held by private companies. And I would like to clarify that these controversial technologies are not currently being used in the Prüm system, but it is so important to consider them within a more broad scenario of uses of forensic DNA technologies. And finally, a particular focus of our work has been the comparison of national cases, and we selected Germany, the Netherlands, Poland, Portugal, and the UK to understand selected in-depth situations and country contexts of national forensic DNA databasing and social phenomena which could develop with the Prüm system. Of course, that for reasons of time limits, I will not have the occasion to provide many details about these so interesting cases. Anyway, I will summarize the most relevant aspects. And so the selected countries differ widely regarding their national DNA databases, histories, and size of DNA databases, as well as when and how they got involved in the Prüm system. While the UK holds about the equivalent to 10% of its resident population in its database, Poland and Portugal hold less than 1%. Germany and the Netherlands were among those countries driving the Prüm development in 2008 and among the first technically operational and exchanging DNA data in times when Poland and Portugal were just starting their national DNA databases. Although the UK was among those countries that decided to initiate the Prüm system in 2008, it then withdrew from the system in December 2014, and since 2019 it is currently operational. And I would like to make an important clarification. The exchange project started in October 2015, but actually the preparation of the application for the grant was made 1 year before, so it was sometime before the Brexit process. In any case, although considering the present circumstances, we always thought that it's so important to continue to follow up the UK case, and for the reasons that I will now explain. Summarizing some comparative results, Germany, the Netherlands, and Poland have in common what we call an expansive mode of dealing with Prüm. facilitating smoothly data exchange. They represent examples of beliefs of European integration in the area of law enforcement as to be achievable by the harmonization of scientific and technical procedures between laboratories and police forces in different countries. Germany, in particular, performed the role of the political architect of the initial Prüm plan and attempted to expand it beyond the starting group of EU member states. The Netherlands has led the techno-scientific process of supporting the forensic technocracy across member states through its contribution to the establishment of the technological scientific infrastructure for data exchange, as well as its support for training, pilot tests, and evaluation visits for other member states. However, the Netherlands has also had strong support from Germany and Austria in carrying out these tasks. Poland has, in a relatively short period of time, established a substantial number of connections with member states. So Poland has caught up with the front runners among the member states and took the Prüm process as a stimulus for the establishment, implementation, and expansion of its own DNA database. Portugal and the UK have, for very different reasons, in comparison with the countries mentioned before, a more restrictive and ambivalent modes of DNA data exchange. Portugal, due to its legal and judicial traditions, has maintained a regime of restrictive data inclusion criteria in its national DNA database and has defined very selective data categories for data exchange. In the UK, specific arrangements were installed as conditions for its participation in Prüm. Among these conditions was that they would only exchange categories of profiles from convicted offenders, crime stains, and unidentified human remains, and would not provide access to DNA profile of suspects, one of the other very usual category exchanges across member states. However, a very, very recent update of this situation still needs to be considered. Due to the Brexit and post-Brexit negotiations between the UK and the EU, the UK significantly changed its initial restrictive approach. As requested from the EU, the UK has announced just 1 week ago, on June 15, that it will be sharing its suspect data too. This is a significant change of the previous approach, as it makes a big amount of DNA data available beyond the data from crime scenes and subjects who have been convicted of a recordable offense in the UK. There are acute and urgent ethical and social hazards in the Prüm system. It is not an easy task to deal with the desired principle of proportionality when considering the extent to which the breach of privacy and other human rights is proportionate to the need to respond to criminal offenses. Some still unanswered questions are how to maintain trust and solidarity between EU countries and among different professionals and diverse stakeholders engaged in a more direct or indirect way in the Prüm system. What are the new ethical and social challenges emerging from the more recent genetic technologies applied in forensics. For example, next generation or massive parallel sequencing, which allows a huge expansion in the level of depth and breadth of genetic information, genome-wide data analysis, and potential blurring of boundaries between the criminal and the medical field. And finally, what to expect, if anything, from the announced New World Divide post-COVID. What can be the expected implications, if any, on transnational police and judicial cooperation in the EU? And these are my final words. Thank you very much for your attention.
Thank you very much, Helena. As we are all requested to have the microphones turned off, I suggest instead of applause to use sign language, and it goes like that. Thank you very much for your obviously summary of our research results, but nevertheless covering a wide range of work we did. That most probably might have provoked questions or comments. So I would like to invite all participants to start using the chat function that we have. So please share your questions or comments there, because we will actually gather all questions to Helena Machado and also to our other guests at the end of the symposium in the final debate. So please feel free to use the chat function already now. That gives me the chance to move to another very substantial part of our symposium, which is the panel entitled The Prüm System, Present and Future Challenges. And we invited guests from different backgrounds and bringing different perspectives. So we have perspectives ranging from the political administration of the Council of the European Union with the perspective from Georg Biekötter, very welcome, or the perspective of the Police and Ministry of the Interior of Austria from Leonard Schmitz, welcome, or the perspective of forensic genetics from the Belgian DNA database custodian Séverine Steuve, or from the social science and social studies of forensic genetics perspective from Victor Thum. I would like to join me in this panel. So we also have transformed this idea of having a panel now here. So we are all together in that panel now. And I would like to introduce our speakers one by one. They had been asked to reflect on the present and future challenges from their particular backgrounds and experience. And all of them are in their particular fields and context to Prüm, kind of dinosaurs. So we are really happy to have that bunch of expertise with us that also will stimulate the debate afterwards. I would like to invite Georg Biekötter, who is the political administrator at the General Secretariat of the Council of the European Union, political administrator dealing particularly with police cooperation, at the Secretary of the Council Working Party on Information Exchange and Information Management, which is the former DAPIX group. And he works on the main files related to the implementation of the interoperability legislation, which is also related to the Prüm decision and the PNR directive. I would like to give the word to Georg, who can now also try to share his screen. And yeah, you have already the microphone turned on. The floor is yours.
Thank you very much, Nina. Do you hear me? Yeah, do you see me? Okay, thank you very much, Nina, to the organizers for this symposium for the invitation. It's always a pleasure to participate in those events, and of course a challenge to present Prüm in only 15 minutes. But what am I supposed to say after Helen's intervention, which was wonderful and which was a panorama of all of the most important points. So I'll try to do my very best. And just as to myself, yes, I'm at the General Secretariat of the Council of the European Union in Brussels, actually in home office in Berlin. Nice weather conditions here as well as in Brussels. And I'm dealing with the implementation of the Prüm decisions since 2009. For my background, I'm not a policeman. I'm not a lawyer. I studied political sciences, and I would say that was one of the reasons to get the job for Prüm. My intervention should focus on political and let's say institutional and governance dimensions of Prüm. Now I prepare let's say, do you see my PowerPoint?
We don't yet see your screen. You would need to start screen sharing.
Share screen, and then I have to...
I guess you need to confirm it once more.
Share.
I might share it for you if you prefer.
Yeah, if you do so.
Yeah, sure. Just a minute and I will take care of that.
You will see Rafael Lagrange's screen, which shows the PowerPoint from Georg Piekerte.
So here it is.
Okay. Here it is. Thank you very much. Next slide. Am I to? Is it me too? Okay. I'm working in the field of justice and home affairs. In French, this is JAI, Justice et Affaires Intérieures. That's the directorate JAI. And we are dealing with one of the objectives of the European Union enshrined in the treaties, a development of an area of freedom, security, and justice with respect for fundamental rights and the different legal system and traditions of the member states. That's a quite complex situation. And as all those speakers before me already mentioned, there are these, let's say, natural tensions between, on the one hand, freedom and on the one hand, security and justice issues. I don't want to say that there is a natural trade-off, but so to say that the more freedom you have, the less security, or the more security you have, the less freedom you have. But it's clear that politicians have to find that we have to find the right balance between that, and see that freedom is at the first point in this enumeration of goals and objectives. And we know a quite substantial number of court cases defending the freedom of citizens against the, let's say, powers of the state. Now, realizing, do you still hear me? Realizing the development of an area of freedom, security, and justice means an enhanced cross-border cooperation of law enforcement authorities. Why? We don't have a police in Europe. We only have national police authorities in the member states. And this is a cooperation of, meanwhile, 27 member states. Rights and duties of a policeman, of a national policeman, normally stop at the border, and therefore this cooperation is mainly dependent on information exchange. The cooperation, the law enforcement authorities' cooperation, is extremely complex, not only in terms of different languages, different legal systems, different IT infrastructure. On top of that, please, next slide. We have this European landscape here, and which is blue. This is the European Union, let's say the less complicated cases in information exchange in law enforcement cooperation. Then we have Ireland and UK, and as well Denmark, which have the different opt-in, opt-out rules. With the Brexit, we have a completely different situation for the UK, and on top of that, we have Norway, Iceland, we have Switzerland and Liechtenstein dealing with the GHA and dealing with the freedom area, freedom, security and justice, and dealing with Prüm. And for the next future, we have the Western Balkan states dealing with Prüm. Next slide, s'il vous plaît. I'm working I'm the secretary of the so-called ICSIM working party, which is the Working Party on Law Enforcement Information Exchange within the Council. Here in these working parties, Commission legislation or legislation in general is to be discussed before adopting the final project, the final draft legislation. ICSIM is the abbreviation for Information Exchange and Information Management. And this working parties is ensuring consistency across all GHA information management, information exchange projects. We are addressing the further development of information management. And we are discussing PNR and Prüm developments. It's clear, or it's important to know that law enforcement means the prevention, detection, and investigation of terrorist or criminal offenses. It's not only serious offenses. For instance, Prüm is not on serious offenses. It's on criminal offenses as such. Whereas, let's say the PNR, the passenger name record exchange for flight passengers, is reduced to a list of criminal offenses. Data protection, this is one of the point we always have to keep in mind when exchanging law enforcement information exchange, because data processing interferes with the fundamental right to privacy and to the protection of personal data. That means that data exchange must be lawful and must constitute a necessary and proportionate measure in a democratic society with regard to the legitimate interest of the natural person concerned. All the speakers before me underlined this request. Prüm Treaty. This is the beginning of the Prüm system. This is a convention or a treaty outside the Union's framework. And in the beginning, we had Belgium, Germany, Spain, France, Luxembourg, Netherlands, and Austria, which they had this, let's say, developed this convention on the stepping up of cross-border cooperation in 2005. This convention was open to other member states as well of the European Union, and at the end we had a much higher number of member states. But then under the German presidency, it was decided to incorporate the substance of the Prüm Treaty into the legal framework of the EU by means of the third pillar instrument. Third pillar instrument means at the time we had still this three-pillar construction of the European Union. First the economic area, then the judicial, the foreign policy area, and as a third pillar, the justice and home affairs pillar. Until October 2009, this convention was applied, but then we had on 9 October the last decision of the Committee of Ministers of the Prüm Treaty or the Prüm Convention, and since then we are talking about Prüm decisions. Next slide. Prüm decisions. If we are talking about Prüm today, we are talking about these two decisions from 2008, 615 on Justice and Home Affairs of 23 June 2008. And you see immediately there is a slight difference. Illegal immigration is not part of Prüm decisions anymore. This is dealt with by different legislation. The second council decision is the implementing decision, and it's the implementing decision concerning the automated data exchange. So how to implement Prüm, what kind of data should be exchanged, what should be the formats of data exchange, what are the requirements of data security, what are the requirements of data protection. Member states assist themselves. That means operational member states assist not yet operational member states in implementing all these technical requirements. Technical and the legal requirements on data protection are dealt with at national level because this is not only a question of the neighbor state. The implementation of all of this Annex 616 has to be evaluated by the other member states. After that, there is an evaluation report, and there is a consultation of the European Parliament on the member state, the candidate member state. And after the Council had received the opinion of the European Parliament, the Council can proceed to the formal and final adoption of a draft Council decision to launch the data exchange. I remember that once one of my colleagues in the council, in the former DARPEX working party said, but this evaluation is only about data protection. Yes, it's sure, and it's that's right. The most important point is, in case, beside the technicalities, is the implementation of data protection. Next point, please. Yeah, this automated online, this data exchange refers to three categories of data. It's DNA, it's fingerprints, and it's vehicle registration data. Also, your project focused on DNA. We can neglect today fingerprints and VRD. But the idea is to search the DNA files of other member states in order to get, let's say, a name to a non yet solved crime in my country, so to say, and the investigators hope to find a name to their unidentified data profiles in their own country, in another country. Okay, next. Yeah, here are the structure of exchanging data is similar in all three cases: DNA, fingerprints, and VRD. But as Helena already said, there is this NCP, the national contact point. There are two contact points. The first one is the forensic one. The second one is the so if the forensic scientists, they have to send their request to the database of the other member state, and automatically I would say within 5 minutes, there is an answer, yes or not, hit, no hit. We have an answer to your question. This is done automatically. No human interference is needed anymore. But then if you get this hit, no hit report, you as the requesting member state, you have to decide, would you follow up or would you not follow up this match, and then you have to ask for further information. And both times, you see, the automatic searching is done on the legal national law of the requesting member state, and the supply of follow-up information is governed by the national law of the requested member state. This is not quite easy sometimes. Next slide. What is the state of play in terms of connections today? I would say bluntly, everything which is a white spot is still not yet ready. The deadline for Prüm has been 2011. We are in 2020. You see that nearly all member states are operational, except Italy for the time being. But not all member states are, and even Greece is in principle operational, because they have the right to exchange DNA data, but they don't do that. There's no connection available for DNA data files. But as you can see, it's a bit a patchwork. It's a bit that not everybody is connected to everybody. We see now UK is already connected to 9, not only 7. Last information I got, to 9 member states, and there are more member states in the pipeline, so to say, to connect to UK. It would be nice to say that yes, we are ready. There are no white spots on the Prüm landscape anymore, no unknown connections. But reality is that the pace of each member states to proceed is their own problem. It's at their own discretion, and sometimes it's rather easy. Sometimes it takes a lot. I don't know for which for what reasons they member states not really inform us about the reason why there is no connection yet. And next, please. An outlook. What will we expect in the near future? On Prüm, there are discussions on a Prüm next generation held in the former DAPIX in 2018 and 19. Focus groups focusing on DNA, fingerprints, facial recognition, and VRD and police cooperation, focused on the future development of such exchange, if that has to be improved or not. And delegates discussed a study on the availability of Prüm data exchange, and a new legislative proposal is awaited from the European Commission, I would say, in early summer next year. Then we have in the pipeline the Prüm agreements with Norway and Iceland. Norway and Iceland implement since a couple of years Prüm provisions, but the final green light is not yet. It has not yet been given from the northern countries. And then we have the Prüm agreements with Liechtenstein and Switzerland, which are in the ratification procedure in their own countries. Can't say when these ratification procedures will end, but I suppose this will take still a couple of years. Another point are Prüm-like agreements with the Western Balkan countries. These are done outside the European union framework, but apparently Reinhard will have to say more than me about that, are well proceeding and a good step forward. These are, in a nutshell, I hope I was not too quick, in a nutshell, the current features of the Prüm system at institutional level. Thank you so much.
Thank you very much, Georg. So I do applause like this again. Thank you so much. I would invite you again to share your screen, not to share your screen, to turn on your video. I think that might have been mixed up when you tried sharing the screen. So we move on to our next speaker, who is Leonard Schmitz. He is head of the Central Identification Service Austria and deputy head of Austrian Forensic Services. He is a detective, legal, forensic, and project management expert, and he's working for the Vienna Police and the Ministry of the Interior, Austria, since 1983. He was appointed in 2002 as head of the Central Identification Service Austria and deputy head of Austrian Forensic Services. He is member of the Prüm member state founding group as Austrian head of delegation. And so therefore he has joined the Prüm development process since the beginning. I just would like furthermore to mention here that he's also head of various working groups, head of Austrian delegation in the Formadapics interoperability and the new ICSIM working group, and thus also initiator of the Prüm Next Generation initiative during the Austrian EU presidency. So I would like to give the word to you, Reinhard, for the next 15 minutes.
Thank you, Nina. Thank you, dear exchange team, for this very important conference and symposium, and for to invite me. I will try to give you in 15 minutes, it's not so easy, but I will try to give you an overview about Prüm and the running developments in Prüm. And I think it should be possible. Because
if you would like to share your screen yourself, you can do so. Otherwise, we can do it.
Will you see my presentation now or not?
No, we don't see it yet, but I assume that Rafaela can also.
I will. Just a minute.
If you like.
Sorry for this. I have
no, don't worry. Sorry, just a minute. So here it is. Is everyone seeing it?
Yes.
Thank you very much. Yes, I will try to give you a short presentation. I think a lot of those points I must not repeat because we have gotten very good overview from Helena and also from Georg about the history from Prüm. Could you change to the next slide? Thank you very much. But what we have to do, I think, always is to ask why we share such information on international level between member states, but also above. And what we can do with this very strong tool, this very powerful tool for solving crimes, is we solve a lot of unsolved crime cases by identifying persons when we get links to crime scene stains, biometric stains, maybe DNA profiles, maybe also fingerprint files. What is very important also in the DNA area, we link unsolved crimes by so-called stain hits, means the same offender is acting as a criminal in different member states. With those confirmed hits, we see the movement of such offenders, we see the composition of criminal organizations, and when there is one time such person is DNA sampled and fingerprint, we can solve a lot of crimes in different countries with one hit. We established a true identity. Such criminals or also terrorists use usually always permanent different identities, but by usage of the biometrics, it's not of relevance. You recognize immediately it's the same person. with those person-person sits, which we also have, we can locate, we can arresting wanted criminals. Also, it's not of relevance which alias identity they use presently. And what is presently not regulated clear in the Prüm decisions themselves, but it's regulated in national legislation. We identify unknown dead corpses and missing persons. This is also a point which should be a follow-up development in Prüm next generation, because we have seen this is very important. We have also solved crimes, murder cases by possible identification of dead corpses with links to missing persons. And those target is also in new EU legislation and other legislation, such as the interoperability regulation adopted, and it's and should follow then in the next Prüm generation legislation. Could you change the slide, please? I think to this point, it's not necessary to go in deep detail. As also Georg has mentioned, basically the cooperation, this internal security, police cooperation falls in the competence of member states, but may be shared, those competence also if such is agreed with treaties, and this has been done with the Prüm Council decision. As we start with the Prüm Treaty themselves has foreseen an evaluation. 3 years after go live should have been an evaluation, and if it works, there was from the beginning the target to bring it in as an EU legislation. And as we go live in December 2006 with Germany and Austria has developed that time in DNA the software solutions. We have shared the work and also the costs. With the first mass upload with the Article 4 search with open stains, we have more than 2,000 hits and solved crimes. Takes some time to finalize all this information exchange afterwards. But as this success was known in other countries, a lot of countries want to share those multilateral state agreements. This Prüm Treaty is still in force, and up to now 14 member states are partners of the Prüm Treaty as a multilateral state agreement. But then it was decided that we bring the most important parts. It's the data network system exchange should be changed immediately, and we should not wait 3 years in EU legislation. Additional, we have also such Prüm-like agreements with third country. Prüm system is meanwhile not a European Union system or idea. It's a worldwide acting idea, and we have also additional agreements which, enlarge the cooperation, particularly in the second step exchange procedure. Could you go to the next slide, please? There are also other, legislation which have a strong influence to the Prüm cooperation. Most of them is the national legislation with very different national legal preconditions for storage, for the recording requirements of DNA profiles and fingerprints. And there exists, as I have mentioned, a lot of beyond multilateral international agreements. This is also, I think, one of the important factors that Prüm is not a central database. Furthermore, Prüm is only a system for the exchange of data. So it could work, because with central databases, you will see later statistics from the Interpol General Secretariat DNA database. It is a non-effective database because it's more or less an empty database. Here it's up to the member states in line with that very different national legislation to share information, to check in an anonymous way the DNA data in this case, and only when there is a confirmed hit, follow-up data will be exchanged. This allows very huge data stocks from reference profiles, which can be used as a search platform for the open stains, for example. We have also other European Union legislation, resolutions, conclusions. Some of them are regarding forensic standards. The oldest one is in 1997 on the exchange on the analysis results. This was updated in 2009. But by the way, in this first Council resolution from 1997, it was fixed that each EU member state should have one central DNA database. It takes up to 20 years that really all EU member states have such a central. Some of them have more than one, and of course missed hits then also because they have no systematic checks. Other rules, one of the very important ones is the so-called Swedish Initiative Framework Decision, because here is foreseen that for the simplifying of exchange of information, of the follow-up information, not Prüm first step, Prüm second step, should have a national contact point for this data exchange. This is very important. And this is also one point which should be added in the Prüm next generation in a systematic way, because the Prüm decision themselves refer only to, yes, classical police and justice cooperation for the second step exchange. And what we have seen in the years, that without a national coordination, it does not work really good. And then finally, the Council conclusions from 2018, Georg has mentioned it, that the work or the planning for Prüm next generation for an update that we have used then also as to start our work in expert groups. I will come later on in more detail to this. Please, next slide. I've mentioned Prüm is a worldwide cooperation meanwhile. Each European Union country has meanwhile signed with the United States a so-called Police Cooperation Against Serious Crime Agreement, which is Prüm-like agreement. It's only for 2 data types, because the vehicle registration makes not so much sense with the United States, of course. But it regulates the biometric exchange for fingerprints and also for DNA cooperation. Each of these treaties, it's bilateral state agreements, of course ratified from the national parliaments afterwards. But the DNA cooperation is currently still suspended with the United States by all member states. The reason, therefore, is not that the EU member states will not cooperate in this area. Furthermore, United States have a national limitation, a legal limitation for online access to their national DNA database. Furthermore, it could not start, and therefore it's suspended. Of course, police cooperation is always a reciprocity cooperation, and we could not allow that the United States search in our databases and we have no access to them. So it's presently suspended. It works quite good. We are operative with United States in the fingerprint area since 2017, and we have also developed in cooperation with United States a more fast follow-up data exchange solutions. Next slide, please. A very, very big cooperation which is ongoing, Georg has also mentioned, is the Southeast Police Cooperation Convention. There are more or less 2 legal acts, multilateral state agreements. One of them is in force since 2007. It regulates classical police cooperation, has parts of Schengen cooperation inside and such things. It's a very important treaty, I have to say, because it's also a peacekeeping treaty. At that time, it was not so easy, the cooperation inside the Western Balkan states. Meanwhile, it works good. And meanwhile, in this treaty are 12 partner states. So it's not limited really to the Western Balkans. As you see here, there are also countries inside. Austria is not a typical West Balkan state, but also Moldova. And so the last country which shared those community was Croatia last year. And as update for this cooperation, but the precondition is you must be a member of the core treaty, of this BCC treaty, is the possibility for BCC SE Prüm. And this is presently signed from 9 states. 2 other from the states, it's Bosnia and it's Slovenia, could not sign we have also signed this treaty in 2018 during our presidency in Vienna, because they have a change in the national government at that time. But they want also to share, and they are also observers now in this procedure. And the ratification procedure is running in all countries. The West Balkan countries have finalized the last ones with end of last year, the ratification procedure. and we are presently in the technical implementation support. So it seems that within next years, the first countries could go live. I think it's Northern Macedonia, which is very far. It's Albania, it's quite good. It's Montenegro. They have really also in the technical and organizational implementation made great steps forward. We get here very, very strong support from the European Commission. Those countries will be allowed to use the secure European Union network, the DESTA network, where the whole data traffic is exchanged, not only in Prüm, it's Europol, it's also the Ministry of Finance. The whole data traffic is running between member states and Commission, for example, the Parliament via this network. And the Commission give the green light that also the Western Balkan states could use those networks. This is very important. And it's also important for the strategic EU enlargement strategy for the West Balkan states, because those West Balkan states must be Prüm ready before they could be a real EU member state. So they must have the Prüm readiness, and the creation, the technical creation or preparation, it's 100% EU Prüm. So the first step is fully identical. We have then additional, yes, enlargements for second step, but first step is the same. Please, the next slide.
Leonard, may I ask you to end within the next 5 minutes? I know
Yes,
that there are a couple of slides missing. I will promise to ask questions about Prüm next generation in the debate.
Okay, fine. I will speed up. Here also on the overview about the operativeness status, we have heard it. Go to the next slide. You have also an overview about worldwide situation and data stocks here in this slide. Please change to the next slide. How it works, as we have heard, is a decentralized system, so you have a lot of network connection. It seems it is complicated, but particularly in DNA cooperation, it isn't so. It works really perfect, so we will also make not so much changes in the future. Each country have the possibility to send searches, and this will be done in a systematic way. Please, next slide. So we start always with a DNA kickoff. Last country where we have done this was United Kingdom in July last year. United Kingdom has repeated those mass upload because they have so much profiles that they was not in the position to load it immediately at one moment. So we have meanwhile 3 mass uploads made, vice versa with United Kingdom, and a lot of hits. In total, United Kingdom has more than 40,000 hits recognized. They switch on very fast with the other countries, presently 9 countries, but a very huge data stock, of course. After these initial searches, we start really each new loaded open stain, and each new loaded person profile will be sent systematically to all member states, to all operative member states, and both partners see potential hits or matches, so they can act. Please, the next slide. So what's done the next? When there is a recognized match, the question which is always be done or has to be done by partner state is this match of interest? It will be always of interest when there is a stain hit, a crime, open crime case in own country, and you have a person. Hit means you have afterwards a name to your open crime. Also a Prüm verification and validation has to be done, because the match is not, it's an investigation tool. The match has to be confirmed by forensic evaluation with the raw data, with biostatistic checks and such things. And if it could be confirmed, then it's up to the country which have the interest to get in contact, presently via classical police cooperation, and request the follow-up data. This will be done usually via Interpol channels in about 90%, but could be also made by Europol channel, for example. Next slide, please. Only statistics that you see, an overview. I will not boring you with statistics, but from the efficiency of Prüm. In the first line, you see Austria has since 1997, we was the second country in Europe, which start with the operative DNA database. Yes, 23 years now, and we have in 23 years about 900 hits. with classical information exchange, which are with forms and via Interpol channels, and we process it manually. With the Interpol DNA database, which is Austria also online linked, which exists since 2005, we have about 580 hits. You see the data stock; it's more or less empty database. From this, about 180,000 profiles, about 120,000 are from Austria. So if we have hits, then very often serious cases for other countries, because other countries store, serious crime stains inside, but not reference, and then you have no hits. And in Prüm, you see in total, we have, meanwhile, this is the statistics from end of 2019, about 100,000 hits. Also on the last column, you see the results when we detect wanted persons, which we should arrest, or the justice authorities needs the whereabouts. Next slide, please. Also the development, this is only Austrian stains with stained persons hits or stain hits. On the first column, always DNA and fingerprints on the national success, and then with DNA Prüm success. And you see on the last line, when you have a few, we are now nearly in the situation that we solve additionally, I have to say, near the same number of crimes each year in DNA what we solve with our national database. And our national database is not so small. We have in total about 400,000 DNA profiles loaded in Austria. So next slide. Prüm next generation, I think there's some questions. What's this? Let's go to the next slide. Next slide, please. Thank you very much. I have mentioned this council conclusion from July 2018, what's prepared from Bulgaria and Austria during the presidency together. We was able then during our presidency to create discussion papers and to organize expert groups. Each expert or each member state was invited to work in these expert groups. On behalf of European Commission, there was also ordered a feasibility study by a company. This is always done by Commission. But of course, in this area, it's very difficult for a company to bring, useful results, because this is exclusive tasks of member states and member state experts. We have 5 expert groups in different data types. One of the data types is a new one. It's face recognition. Next slide. And those reports from these expert groups was provided in October, November last year to the Commission and also to the member states. And Commission is now in the procedure to prepare a Prüm next generation legal draft, which we hope now. The COVID has stopped some things, but we hope that in beginning next year, the first draft could be presented to the member states, and the negotiations are ongoing that time. What was the outcomes? I'm referring here mainly to, not to the other parts, only to DNA. What we have seen is that the first step works really excellent. There should not be so much adoption, particularly in DNA. But we see the second step could be much more better, could be much more faster. We need those national contact points also in an organizational structure. We need a change of the legal structure, because presently this creates a lot of problems. I have mentioned before new forensic standards, technical standards. It's a real, the Prüm implementing decision is also a legal text. Means you need for changes the involvement only for email addressing, basically. The involvement of the European Parliament and Commission, and so this could not work. This must be in the future technical documents in form of implementing acts or whatever. So next slide, please.
Reinhard, I need to ask you to pick one last slide.
Yeah, one last slide. I will not go here in detail. You see here some points which was discussed. The more important are, marked with bold letters. But in DNA, there are really not the big changes. It's very, very small changes. It's more technical updates in parallel, I have to say, with HTTP solutions, not with mail solutions. So it should be faster, the second step exchange. Next slide, please. And what is an ongoing discussion is also the message routing. So because presently we have really exclusively P2P between member states. We have proposals from EU-LISA, from Commission now, which from technical point, this could be also easier to use a central message router, which forward then those. But those more or less all of them. Next slide, please. What should we keep? This is also important. It should be also in future a binding human expert intervention for forensic hit verification. No automated data transmission for when we have a match. This is in DNA, it's anyway clear, but this could be with fingerprints or face recognition indifferent, but we need always, we request the member state experts say we must have also in future such human interventions. Next slide. And this is, I don't think that it's necessary to discuss so much with you. We have not the time for this, but this should be the technical system architecture. You see the first part is Prüm as it exists now. What we plan here is that the second step, information exchange with name, type of crime and such things, when there is a confirmed hit and when there is a request, could be transmitted in a structured form with predefined data fields via the same network and not via classical police cooperation such as Interpol. That's it. So thank you for your attention. That's it.
Thank you very much, Reinhard. I will jump immediately to our next speaker, and I'm very happy to introduce Séverine Steuve, who is custodian of the Belgian DNA database from the National Institute for Criminalistics and Criminology in Brussels. She studied science, chemistry, and wrote a thesis in molecular biology at Free University Brussels. She joined the National Institute for Criminalistics and Criminology in 2009 and is now expert at the National DNA Database and manager of the Belgian DNA Database since 2017. Séverine, the floor is yours.
Thank you very much. I will immediately go to my presentation.
Yeah, try if you can share the screen. Otherwise, we can do it as we did it with the previous speakers. Yes, I think it's working. Yeah, you just can put it full screen and then.
Yeah. Is it okay? Yeah. Okay, thank you. So thank you very much to invite me to give a presentation about the experience of Belgian DNA database with Prüm and the benefits of such international exchange. Though in the beginning, there was no mention of any international data exchange within the first Belgian DNA law in 1999. So we had to change the law before the signature, after the signature of Treaty of Prüm in 2005. It was only in 2011 that the new law was published and finally implemented in 2014. So we started to exchange with our first neighboring countries, were Netherlands and France. So now, last point here was that we created a new missing person database since July 18. So I talk about it later. So that was a little bit the history of the database. After we started the exchange with our first 4 neighboring countries, so here the Treaty of Prüm, it takes several years because we had no law to allow it. So now in 2014, we start to exchange with Netherlands and France, then in 2016 with Germany and Luxembourg. After that, we had to wait a little bit to manage all the hits we had received, and also to wait for an agreement with the Federal Prosecutor Office, who is responsible for the step 2, so it's an ICP step 2, and also to increase the number of DNA experts, because there were a lot of hits and you have to manage that. So with that 2 points agreed, we had the possibility to increase the number of operational countries. And so since 2017, 2018, we reached now to 20 operational countries. So the first 4 countries, then 3 more in 17, 6 more in 18, 5 more in 19, and here in 2020, we start with 2 new lands, and we had the idea of beginning also with Denmark, Ireland, Hungary, Cyprus, before to start with UK in September, but the actual situation changed a little bit how ID. So we hope still to begin with UK in September and to be operational with all countries very soon. Wow, that's a state of play. So just one thing more before I show you the results of our DNA exchange with other countries. We speak here about the exchange of around 56,000 convicted offenders, Belgium, convicted offenders, almost 3,000 suspects, almost 33,000 crime stains, but also 160 missing persons and human remains. So few, because as I said, our missing person database only began some 2 years ago, but we already had 2 successful cases where the Belgian authorities had no ideas that there could be a link with a foreign country. So I would like to take the occasion to share with you my point of view about the interest of exchanging missing person and human remains profile between European countries, because it is not always the case, because there are different laws and not always allowed in different countries. But very interesting. So now I would like to share with you some interesting results. The first Article 4, so kickoff exchanges with our neighboring countries gave a number of hits, from which a quite large percentage of them were between an unidentified Belgium crime stain DNA profile and a person profile registered within the DNA database of foreign countries. So as you see here, with Netherlands, 34% of the matches were with a Belgian unidentified stain and a person in Netherlands. Same here with France, 78%, with Germany, 43%, with Luxembourg, 27%. So very interesting here. If we look to the type of criminality implicated with these hits, and if we choose to look to the 7 more important categories of crime, we see here drugs, homicide, threats, sexual assault, criminal organization, and burglaries. So we see that most of the time we deal with burglaries. And theft with violence is also a type of burglary. So the results are given in percentage of the amount of hits after Article 4, specific country. So here, most notable results are with burglaries, always the biggest amount, but it is also the case for our database. We have a lot of crime staining for burglaries, so that seems logical. For burglary with violence, it was the 2nd place with France and with Germany. For criminal organizations, especially with Luxembourg, 2nd place. And for drugs, especially with remarkable results with Netherlands, what the 3rd place with Netherlands. If you try to go to a little bit further than the usual statistic, we could use our results to derive operational and strategic information about the nature of cross-border criminality. Patrick Geniot is one of our researchers at an ICT, built a cartographic representation of the international hits we obtained in Belgium. So here, holding in mind that there is a specific repartition of cases per district in Belgium, so darkest are the more lot of cases, and looking to the cases where a hit was found with a specific foreign country, here Netherlands or France, we see that the Belgium cases that gave a hit with the neighboring country are mainly found in the districts specifically along the border with that country. So here for the border with Netherlands, and more in the south part of Belgium for the border with France. It seems maybe also logic. And for type of crime that we noticed, it was mainly for burglaries, as I said before, but also here specifically for drugs cases. If we look now to the other 16 countries with which we are operational, after the first Article 4 exchange, we obtained more than 11,000 hits, from which 47% are with a Belgian stain and a European person, so a person registered in the foreign database. Among these countries, I took only the 9 countries where we had the most hits, more than 100 hits. More than 50 hits after the Article 4. So the most remarkable results are that you see also here that most of them are for burglaries. Crime such as burglaries and criminal organizations were the most important with Austria, Spain, Lithuania, and Slovenia. Then for sexual assault, we had a lot of results with Sweden, Finland, also Romania, but Romania there were less than 100 matches, so maybe the amount of matches not too large enough to for this type of statistical interpretation. So to get in mind. Also for Poland, there was a respectively relative large amount of hits for homicide cases, but here also it was less than 100 hits in total, so maybe too small, but quite interesting. And with drugs, we had a lot of hits with Czech Republic also. One of the specialties we remarked. If we now quickly look to the amount of new hits per month obtained after an Article 3 exchange, like Renard told us just before for Austria, we also reached almost the same number of new hits per month with the national DNA comparison in Belgium and with the international comparison, almost the same. The most of them are obtained with France, first one here, with Germany, with Netherlands, then after with Austria, Spain and Sweden, here Spain and Sweden, and also Luxembourg. If we look to our more than 12,000 clusters, so a cluster is for us means that DNA profiles match together and that they correspond to a unique person. So almost the same thing than 12,000 persons. So 83% of our clusters include a stain and person profile, so they are identified, and 15% of our clusters have only stains, so it is unidentified clusters. Among these 83% of clusters, there is a large part, so 58% that are linked with a Belgian convicted offender. So they are identified thanks to convicted offenders in Belgium, 11% with a suspect in Belgium. But what's most interesting here is to say that 31% of our identified clusters are identified thanks to international exchange. Here it is only because we have a match with an international person in a foreign database. That is the most beautiful result for Prüm for us. That shows the interest of Prüm. So that was my conclusion for this slide. So almost 1/3 of our identified cluster are identified thanks to international person. So what are our perspectives for Prüm in Belgium? It took a long time indeed to begin, but now I think we convinced our Belgian judicial world of the use of such exchanges. And as I said, our first plan was to be operational with all countries at the end of 2020, but now a little bit may be delayed. But I hope we can begin with the United Kingdom in September, and then the 4 other ones will follow quickly. We also would like to promote the exchange of missing persons profiles. As I said, we think it's a good reason to, and good way to solve cases, cold cases sometimes. And we also would like to perform a cartographic analysis, such as I showed you for Netherlands and France, but with the other countries, to see if there is also such pattern, such geographical repartition of the cases in Belgium, specific or not. If there is no border with the foreign country, what is the representation in that case? And the last step, we would like we are implicated with the NCP Step 2 in Belgium, in a European project, funded project, to automate the Step 2 process, because in Belgium it is still a little bit manual, and also the more easy way to communicate between Step 1 and Step 2 in Belgium. That will be quickly after. So I would like to thank you for your attention. Maybe I was too quick. Don't hesitate to contact us later. And if you have questions, because I see that here it is not the easiest way to exchange IDs maybe, but we are there if you want to speak about it later. Thank you very much.
Thank you very much, Severine. My applause for the presentation as well. I would like to remind everyone participating in the symposium, if you have questions or comments, please start sharing them in the chat function. As we are a little late in our schedule, we will extend the time of the event up to 10-15 minutes. But in order to make sure that your question or comment might be accommodated, please start sharing it in the chat. Also, if you would like to raise your question yourself, would like to speak yourself, please announce that in the chat. I would like to give the final word to the final speaker in this panel, to Victor Prüm, who is an independent social science scholar. He obtained his PhD in social sciences in 2010 from the University of Amsterdam. He's been researching forensic practices for over 15 years. He is an expert on Prüm. In 2018, he delivered a study on the cross-border exchange of DNA data in the context of the Prüm decisions, which was commissioned by the European Parliament's Policy Department for Citizens' Rights and Constitutional Affairs at the request of the LIBE Committee. The LIBE Committee is the Committee on Civil Liberties, Justice and Home Affairs. And I would like to give the word to Victor.
Yeah, thanks so much for the opportunity and also for organizing this fantastic symposium, and also for all the work of the exchange team with respect to the organization, but also all the outstanding academic work and all the publications that you've been able to give to us, to the community. So today I'm going to read out my presentation, and it's about the Prüm decisions and whether or not it's good governance. So on 22 March 2016, something happened that we should never forget, because terrorists coordinated 3 bomb attacks in and nearby Brussels. With 32 victims, those suicide attacks caused great grief and sorrow, which is felt until today. So 2 days after the attacks, the police in Paris found automatic rifles that were related to the terrorists. These rifles were forensically re-examined in January 2018, and they lifted DNA traces from those rifles. They were then subsequently uploaded to the DNA database of France and exchanged in accordance with the provisions of the Prüm decisions. And they were and they matched 3 individuals in the national DNA database of the Netherlands. Those individuals were arrested in June 2018, so 6 months after the first match. So this is a very brief example But I think it's important because here, you see how the Prüm regime gives testimony of its power. So DNA samples obtained in France match DNA reference profiles of known individuals in the Netherlands in relation to terrorist attacks in Belgium. Simultaneously, this small example also underscores one of the biggest problems of the Prüm regime, and we've heard that already. And the problem is that it took the forensic experts and authorities in this very serious case, so a terrorist attack that killed 32 persons, and it took them nearly 6 months to confirm those matches and report, process, and follow up on the information. So in my study on the cross-border exchange and comparison of forensic DNA data in the context of the Prüm decision, as well as in a scientific publication written together with my esteemed colleagues Ravel Granja and Annika Ludwig, it was recorded that step 1, the actual Prüm decision, functions as it is supposed to do. It generates leads for authorities involved in solving crimes. However, step 2, the follow-up procedures where authorities commence exchanging information leading to the arrest of suspects is problematic. And the fact that it took nearly 6 months between the first found hits and the arrest of the 3 individuals living in the Netherlands provides insight into the complexity of DNA matches, as well as cross-border police and judicial cooperation. Considering the limited amount of time, I want to draw your attention towards 2 urgent problems of the Prüm decision and its regime. First, since its introduction in 2005, the Prüm Convention and later also the Prüm decisions has been critically regarded by, amongst others, scholars, human rights organizations, the European Data Protection Supervisor, and members of the European Parliament. Among the critique was and is that the Prüm regime lacks transparency and accountability. So here, I unfortunately have to observe a tragic irony. The tragic irony is that after more than a decade of such criticism, the lack of transparency and accountability has yet to be resolved by the Council of Europe. A champion, so the Council of Europe, of and actively promoting the so-called 12 principles of good governance, including openness, transparency, and accountability. But in this case, it's not adhered to. The second problem I want to address is related to the first. The study of for the LIBA points at the lack of any quantifiable, objective, and accessible information regarding the Prüm regime. Only with such information it becomes possible to independently assess whether the Prüm regime as a crime control instrument is a proportionate measure. In other words, it's impossible to objectively answer the question whether the Prüm regime meets the democratic standard of proportionality. While the two referred to studies mention several issues that require your attention, now I just draw your attention towards 2 issues that are problematic regarding the Prüm regime. It's not governed according to liberal democratic principles of openness, transparency, and accountability, and it's impossible to independently and verify and objectively determine proportionality of the regime. A solution to both problems is making data available regarding, inter alia, the volume of comparisons, the number of hits, the number of reported hits being followed up, leading to cross-border exchange of personal information aiding to criminal investigation. And finally, how many of those hits are used as evidence in a court of law. In addition, what are the regime's financial consequences? And how often is someone arrested after a Prüm hit but turns out to be innocent? Some of this data is available. Mostly data that's part of step 1. See, for example, the document Proposal for Common Statistics Regarding DNA Data Exchange from 2011. Despite availability of this data, that data is not publicly available. And then when I was drafting the LIBE report, I requested to receive a document, number 5509/18, that includes statistics and reports on automated data exchange for 2017, and which is based on the data provided in accordance with the proposal for common statistics regarding DNA data exchange from 2011. So here's a second tragic irony. So following my request to receive that document with statistics on data exchange, I received a rejection from the so-called transparency unit. I was informed that the most basic information about the number of profiles and the number of matches is considered detailed operational information, and that disclosure of such information may undermine the protection of the public interest as regards to public security. So that's the answer I got from the Transparency Unit of the Council of the European Union. And so please understand, like, this kind of information, so the number of matches with another country that Reinhard just showed us. So thanks for that, Reinhard. But that kind of information is considered to be, if that would be shared, a threat to public security. While finalizing this presentation yesterday, I noticed that the requested document, so the 550918, has been put online eventually. Yet much of the most relevant data, for example, the number of DNA matches between countries, has been redacted. So on the slide you see deleted. So that's all the information about the number of matches. So my suggestion towards governing, to those governing and coordinating the Prüm decisions is to adhere to the principles of good governance, including openness, transparency, and accountability. I realize that this on first sight simple solution is unruly due to technical and political obstacles and constraints. On the other hand, when policymakers and crime fighters are talking about increasing the scope for surveillance and crime control technologies, like forensic DNA typing, we're typically told that if you have nothing to hide, you have nothing to fear. But would that mantra be true, or if that mantra would be true, why does that not? Why does that only apply to citizens, and why does it not apply to those involved in managing and coordinating the Prüm decisions? Why does making available accurate and complete information regarding the exchanges in the context of Prüm undermine the protection of public interest and public security? So here's my final and closing statement. As long as information that provides insight into the effectiveness and utility of cross-border exchanges is not available, the implementation of amendments to the Prüm decisions, the so-called Prüm next generation, should be postponed. Thank you.
Thank you very much, Victor. We thereby concluded the panel presentations, and we have now another 10 to 12 minutes left for the debate, and I will pick up questions that have been shared along the chat already. Not all of them have been dedicated to specific persons, so I will suggest, Victor, maybe you can just end sharing the screen.
Oh, sorry, I thought I did that already. No, this is...
Sorry, it was me. Sorry.
No, sorry. So I will pick up chronologically as the questions occurred, and I will suggest persons who might be willing to answer if it was not clearly indicated yet, and you confirm if you want to answer. So we had a first question from Rafaela, can you turn off your microphone? So we had a question from Fernando Ruiz Dominguez, Deputy Inspector of the Crime Scene Investigation Unit of the National Police of Spain and PhD student in law. I would like to double check maybe with Elena if you want to pick up the question, but of course also other people from the panel might have the answer to that. The question was, is the European Union considering the possibility of carrying out DNA exchanges in cases of familial DNA searching? I will already list the other questions to the other speakers so that you can start thinking about the answer. So we have another question who was posed by Helen Wallace, who is Director of GeneWatch UK. And I might propose that this question could be picked up by Reinhard or Georg. The question is, miscarriages of justice can occur if cases rely on a match alone, referring to examples from the US. Does the European arrest warrant require corroborating evidence or only a match? If only a match, how could safeguards be introduced? We have another question from Dr. Monica Nogel. I think that might be the right order of names. Please correct me if that's wrong. That question I leave still open, like who might answer that best, but please notice all of you. Do you have any information whether the Action Plan European Forensic Science Area 2020 will have any continuation in some form? That was the question from Monica. Then we have another question from Annalisa Pilitza, who is a professor at the University of Bologna. And it's a dedicated question to Georg Biekerter, who might have started to answer that, but maybe share it with all of us. So the question is about the Prüm state of the art. What do you see as reasons for jeopardized adhesion, in particular? A, some countries not adhering, and B, some countries sharing data only with a few other countries. If Reinhard Schmitz wants to add to Georg's answer, that's fine. Then I have a question from our colleague Aaron Amankwa to Severin. And the question is, of the total hits obtained via Prüm, how many hits contribute to investigations and lead to the resolution of cases? Also, what are your suggestions on improving the effectiveness of the Prüm system and the impact of hits? So we have another question coming in from Tiago Pereira, who works at the Center for Social Studies at the University of Coimbra. And that is a question for Helena. As Tiago is interested in the socio-technical dimensions of these processes, and he's referring to Helena's presentation, which highlighted the differences in national contexts in their adherence to the Prüm Treaty. And the questions are two, actually. So first, did the study consider the role of Prüm expert committees in new standardization processes and potential controversies therein, or the extent to which the participation in the international technical committees in Prüm has influenced the national debates or national technical or legal approaches to DNA databases and exchanges of DNA profiles? And as we have now two more questions here, I also will read them out already, and then the next ones coming in, we might see if we have another chance for a second round. But first goes, I don't know if it's Mrs. or Mr. Castella, head of the Forensic Genetics Lab of Western Switzerland. Question to Severin. Concerning the advantageous matches, do you have an idea of the number of DNA matches obtained between a single crime scene sample and several persons? And I take just this question now also for Helena from Carmen Osuna, who is anthropologist, professor at National University of Distance Education. Please could you deep or extend in some of the ethical and social challenges that you talked about? Or is there any paper where I could read about it? So those questions I take in for now. I also would like, as we have questions for all panelists but Victor, and I'm just quickly double checking if there was another one. I also would like to share this last question also with Victor from his own research, if he would like to add to Helena's answer. Okay, so as there is only one last, I will take it in now and I will make a cut now. The very final one goes also to Reinhard, maybe. Are initiatives to extend the Prüm regime to other biometric technologies such as facial biometrics, as you have been touching upon this already. So I would like to go in the order of the speakers that we had during the program, which means for brief answers, unfortunately we don't have that much time, I would like to give the word to Helena to the questions mentioned before.
Thank you very much, Nina. It is not an easy task to see all the questions at once. I think I will try to answer all the ones that were directed to me as short as I can. So first, regarding familial searching, there is huge difference in different jurisdictions regarding the use of familial searching. And considering the case of European countries, in most of them, this is not allowed for criminal identification. Well, but if I am wrong at this aspect, I will then pass the word to Rafaela Granja, who is the member of the exchange team who has widely and extensively studied the specific topic of familial searching. Regarding the question posed by Tiago Santos Pereira of the role of international committees and international group of experts working in Prüm, there is a clear separation regarding who is involved as being in the role of being a national contact point from Prüm. And there are different professional and epistemic cultures. So I would make a clear separation between people who work with genetics, so in forensic laboratories, and people who work in police forces and who are directly involved in criminal investigation. And what we could notice is that there is an impact regarding in what concerns international scientific cooperation, and that has impacts on how national contact points for the Prüm system develop their scientific and technical practices. But at the same time, we could see that there is this sense of lack of cooperation, let's say, between people working in forensic laboratories and people working in criminal investigation. So it is, very, as Georg Bekötter has mentioned, it is a complex cooperation because we are talking about people who are from different countries, so their practices are limited by different national legislations, but at the same time, they belong to different worlds. The world of forensic genetics, the world of ICTs, and the world of law and legal authorities. And finally, the question posed by Carmen Ozuna, unfortunately, we don't have time to elaborate more regarding ethical and social issues. I would say that one relevant point of concern relates to the potential of using what forensic geneticists call false positives and false negatives in legal actions. Also issues regarding data protection, and the most point of relevance is when after a DNA match, we have the so-called step 2 for the Prüm system, which is when personal data related to the matches are actually, exchanged, and we see very clear differentiations on that, because the kind of personal data law authorities are allowed to exchange depends on national legislation. Anyway, we have many papers on these ethical and social issues that you can consult on our website. In case you have any difficulty on accessing to them, we'll be pleased to send the papers to you. Thank you, Nina.
Thank you very much, Helena. I would like to give the word to Georg. There was at least one very explicit question to you, but I thought you might be able to answer on a few others. If you haven't catched everything I mentioned, I will repeat it, but maybe you can also start with the one from Annalisa Pelizza, which was directed to you, and then follow up on others.
Yes, my reply to Annalisa is it's very difficult to get information from member states why they don't proceed in the way we expected, but most of them, so for the time being, there's only Italy, which is not yet connected at all, and Greece. And there are infringement procedures from the Commission against these two countries. These are open cases. I can't say anything about that. But why are member states proceeding at their own pace, sometimes quicker than others, sometimes slower than others? I would say this is a question of budgets. This is a question of human resources. And as Severin a couple of minutes ago explained, when Belgium started with the neighboring countries, they first of all got a load of hits, and they wanted to see how much time it costs to cope with that workload. I see that. I would say that is one of the main questions: the workload expected, how to deal with that, and how to organize oneself at national level. And the other question, whether the UK will remain a Prüm participant after the Brexit, it's a bit difficult. So the current legislation, the current decision to exchange DNA data ends with the Brexit. Whether the UK will be part of DNA data exchange after the Brexit is part of the negotiation currently ongoing with the Commission and the UK on the future agreement, on the future partnership agreement with the UK. Okay. Yeah.
I'm just checking. Can you pick up also on the question from Helen Wallace regarding the European arrest warrant?
I'm afraid I'm not that much familiar with the European arrest warrant, but I would say a match is not really, you have to confirm a match and you have to do much more work on a match before this has evidential value. I can't see that, I won't say that this is impossible, but I don't think that only a match would be enough for an arrest warrant. But this, okay. I would say, I would know better.
Yeah. So then I also would suggest to move on to Leonard Schmitz, who also might be able to say more about that particular question. Rainer, do you want to pick up a few questions that were addressed to you?
Yes, thank you very well. Yes, I think to the one question Georg has mentioned it, there are meanwhile only two countries. One of them, yes, have not done really their work years ago. It's Italy. The other one, it's Greece, which we did not know exactly why they did not switch on, because they are fully ready. They have made the evaluation. They could switch on, and I know the police authorities and justice authorities will do this. But it seems they have a backlog in national implementation of EU data protection legislation, so far as I have heard from there. And to the second question, why are not all countries with all? This is exactly what Georg has mentioned. When we have informally, we get back the information, we have to less stuff. And when we go live with countries with huge databases, we could not handle the many hits, the many matches. This is also a question of, yes, it has to be raised more or less to the political decision makers, I think, so at the end of the day. One question was action plan, European Forensic Area 2020 influence. Particularly here in the Prüm cooperation, we have the framework decision for accreditation of forensic service provider. This is exactly this what this European Forensic Area 2024 see for different areas, accreditation, quality assurance in the forensic area, and in Prüm it was made. So because there is a need, and this will be also checked in the evaluation visits, when a country goes live or before it goes live? Are there the DNA labs? Are there the forensic verification and analysis report? Is accredited external quality assurance, yes or not? So I think in Prüm this has to be done. Then was another question, arrest warrant perhaps. Yes, arrest warrant, a match means nothing. A match is not the end of the investigation. A match to a person profile is the beginning of the investigation. That moment you have a name, that moment you could start classical investigation, and it's evidence, of course, when this is clear. But this is the start of the investigation, and it's only one of these evidences. It's up to the justice authorities afterwards to prove this evidence and to make decisions, maybe a European arrest warrant. But I don't think only a match, because before it has to be confirmed anyway. And additionally, it has to be cleared, could the person be the offender, or maybe he has also access rights to the crime scene. This has also to be checked. And one last question, if I have not foreseen.
There was about
yes, the extension.
biometrics.
Extension, other biometrics. Yes, there is a recommendation in the expert reports for face recognition, extension for face recognition. The expert reports are meanwhile also published in the internet, so if you search it, you see exactly what is recommended there. Face recognition technology, it must be checked very intensive, is meanwhile best suited. And it's very similar then to the work for forensic dactyloscopic data, trace work. Means when you have an unidentified criminal with a picture which the quality is sufficient enough, if a search on the national face recognition systems was negative, that you could have then afterwards a much more reference data stock to search the reference pictures, face mugshots pictures in partner countries, also in the Prüm functionality, means anonymous before, with afterwards following forensic confirmation, and then with starting information exchange if there is a. It's very similar from the technology and also from the forensic background than the work with dactyloscopic stain data. This is planned or is recommended. We will see the outcome at the end of the discussions.
Thank you very much, Reinhard. We have two questions for Severin. One was about how many hits contribute to investigations and lead to the resolution of cases, and the other one was about advantageous hits.
Yeah, about the amount of hits that led to the resolution of cases. The thing is that we don't have that answer easily, because there is a difference between the NCP1 and NCP2, and even at step 2, it's not so. As I said, it's not a totally automated process in Belgium. So they would like also our NCP2 would like to have a more informative IT program to have statistic on that, and to could analyze how many times magistrate in Belgium ask a question to the foreign country, and in how many times it's led to a judicial decision. We don't know for the moment. We have some news because we heard of a specific case, but we don't know in the large amount of hits that we report. We don't know how many give a real input at the end. That's one of the goals of this new project that we have with the prosecutor office, federal prosecutor office. About the advantageous matches, yeah, indeed there are a lot of cases, clusters, where we have a match between a stain and several persons, sometimes in different countries. That's because the person were convicted of suspects in different countries, okay, but also within the same country. The best example is for France, where for each case they took a sample from the person and they register it in the database. So if you make an exchange with France, you will have several times the same person, the hit with the same person. That's a thing that we cannot avoid. In Belgium, we try to do it in another way. It's to have a unique code number, because it's anonymous, unique code number for one person. And normally, if the person was sampled one time, normally it has not to be sampled other times in Belgium if it's implicated in other cases. So normal, we should have only one person. But voilà, it depends of the legal framework of the other countries. Voilà. As for the question of Georg, he talked about the workload that they do, that we take a lot of time because before we start with other countries. It's true, there is the workload, but also the legal problems are there, and also human resources. And there are two different things that are of politic decisions also, because you have to give money to implement things, to have more persons to handle that matches also. Voilà.
Thank you very much, Séverine. We have 1 or 1.5 questions for Victor. I would like to take up a final question that popped up while the discussion was ongoing, which was particularly directed also to Victor. That is from Álvaro Mendes, who is assistant researcher at I3S at University of Porto. And the question is, considering the blurring between the context of forensic and the medical health field, could you please share some thoughts on what are the views you think the genetics professionals community holds regarding the ethical and social issues posed by the most used DNA technologies in forensics? Victor, if you also want to add to the general question about social and ethical challenges, and maybe want to recommend a good introduction to read, please feel free to do so.
Okay, thanks again. So to start with the social and ethical issue, I think I can combine it with another question. That was the first one on familial searching, and the practitioners may correct me if I'm wrong, but considering the fact that a match can be reported if there's a hit on a minimum number of 7 loci, I can imagine that a real crime fighter would upload a complete DNA profile, but only with 6 or 7 loci, and see if it matches another DNA profile in the database. Because then you would generate probably like 100 or maybe 1,000 near matches, and you could do like more research on that. So in that respect, I think there's already the possibility of familial searching. But it's also, of course, dependent on the national jurisdiction, the national legislation with regard to familial searching. In the Netherlands, familial searching is allowed. Whether any of the uploaders of the profiles will do this, I don't know, but it would be interesting to know. So that would be one social and ethical issue for me. Yeah, there's tons of articles and books written on the Prüm decisions that also address all these social and ethical issues. So I think the work by Elena and all the complete team of Exchange is a very good start. I also contributed some articles which are also good, I guess. So yeah, you can send me or the Exchange team an email for further references. And then with respect to the question about the blurring of forensic and medical practices, on the one hand, I'm not really scared of that, because I think in medical practice, they use a very different set of DNA markers, which are, yeah, they just don't fit their STRs. So in that respect, I'm not so afraid that police authorities will start looking and searching for medical databases or in medical databases, because that require other information. It maybe would be possible to ask for samples of individuals if those samples, if those individuals are, yeah, if they can't find those individuals, or maybe if they pass away. So in that respect, there may be some like blurring of practices. I also think that many medical doctors will be hesitant to provide that kind of information, because there's always this strict division between what police does and what medical doctors do. But I'm more worried about like this new development where police and other authorities start using these genealogy databases like family tree and those kinds of databases to solve and to crack old cases, which is something that will require a lot of attention from many people in the field. So that's it.
Thank you very much, Victor. And thank you everyone for extending the planned time until now. I'm happy we are still with 95 participants. So thanks for your patience. I won't close, I will close the debate now, and I would like to do so by thanking everyone for participating. However, the last word has Helena Machado, and just in case you would like to pick up the final question that also mentioned you, please feel free to do so, but we also have to consider that we are already quite over the schedule. So thank you all for joining, and the word is yours, Helena.
Thank you very much. We will end today's event with lots of inspiration, and I would like to thank you all for joining this symposium. I would like to thank the European Research Council and all the members of the wonderful exchange team for making this event possible. I would like to thank again for all the invited speakers and all of you for your active participation and your comments and inspiring questions. I look forward to continue beyond this event the very stimulating exchange of ideas that we had today. Perhaps we could organize a new event about the Prüm next generation, which I think will be on the agenda in a very acute and important way. I trust that you all will have further inspiration on how to address the ongoing and present challenges of the Prüm system. I certainly will. Thank you very much, all of you.